The California Consumer Privacy Act, CCPA, grants consumers rights related to the collection, use, and sale of their personal data. Signed into law in June 2018, the new regulation comes as a response to a multitude of businesses targeting Silicon Valley firms that are making headlines for mishandling or exploiting private data. Who must comply with the California Consumer Privacy Act? Organizations that simply conduct business with California residents and satisfy one of three thresholds must be CCPA-compliant. Has an annual gross revenue in excess of $25 million. Buys, receives for commercial purposes, sells, or shares for commercial purposes, alone or in combination, the personal information of 50,000 or more consumers, households, or devices. Derives 50% or more of its annual revenue from selling. The CCPA requires businesses to give consumers certain information in a notice at collection. A notice at collection must list the categories of personal information businesses collect about consumers and the purposes for which they use the categories of information. Overview of a business responsibilities to be CCPA compliant. Implement processes to obtain parental or guardian consent for minors under 13 years and the affirmative consent of minors between 13 and 16 years to data sharing for purposes. Do not sell my personal information link on the home page of the website of the business. Designate methods for submitting data access requests, including a toll-free telephone number. Update privacy policies with newly required information, including a description of California residents' rights. Avoid requesting opt-in consent for 12 months after a California resident opts out. How can a business know if they are CCPA compliant? Consulting firm PricewaterhouseCoopers, PwC, created CCPA Watch to report on emerging benchmarks. Their research covers three specific areas. 1. Offering a Do Not Sell (DNS) link on company websites. A PwC team analyzed the websites of the 600 largest publicly traded companies and the 100 largest private corporations. As of mid-February, 16% of companies offered such a link, actually higher than was predicted. 2. Offering CCPA rights of access and deletion beyond California residents. PwC recommends organizations plan for the long term by providing these same rights to all consumers. 3. Operating a CCPA privacy rights portal. PwC researchers found operational CCPA rights portals on only 40% of the 600 company websites they examined. According to CCPA, companies need to verify a user's identity to a reasonable degree of certainty. How are consumers affected by CCPA? The CCPA grants consumers the right to request a business to disclose any of the following: all data collected about the consumer, the categories of sources from which that information is collected, the business purpose for collecting or selling that information, third parties with which the information is shared. What rights are consumers entitled to by CCPA? This landmark law secures new privacy rights for California consumers, including the right to know about the personal information a business collects about them and how it is used and shared, the right to delete personal information collected from them, with some exceptions, the right to opt out of the sale of their personal information, and the right to non-discrimination for exercising their CCPA rights. What are the punishments for breaking CCPA rules? Effective January 1, 2020, organizations have 45 days to respond to any verified consumer request under the CCPA. EU GDPR violation penalties. GDPR has a tiered approach to fines with the EU law on data protection and privacy. If you liked our video, please like, subscribe and share.